want him to get his driver's license. I'm going to be quite honest. I was getting sick of seeing his face in my courtroom.
Fair enough.
That's in a funny way. Yes. Because he would come here and then he would leave, he'd post bail, and then he'd go and he'd drive again and he'd be back here and he'd post bail and he'd do the same thing. I want him to get his driver's license. I'm going to be honest. I don't know why, because I don't have a letter in my file. I don't know why it was requested. It makes me feel better, Miss Austin. Sorry. And that's why I like memos. I don't know what they do in Pierce County or other counties that you appear in front of. I like a memo so I can be prepared to have an idea of what you're asking for and why you want the hearing. Because quite honestly, I'm like, okay, what has Mr. Java done? Has he driven now without his driver's license? Those things. That's all good to hear, Mr. Java. You're not here.
Just down the hallway.
Were you in the last hearing?
I did it by Zoom from 1:15 and had just enough time to get here.
Yeah. Oh, that's great. Okay. We will go on the record in the matters 25 CF 148, 25 TR 880, 881, and 882. State of Wisconsin versus Jacob Hazeltine. The state appears through District Attorney Kevin Schmidt in person. Mr. Hazeltine appears in person with his counsel, Nicholas White. We're set today in this matter for a plea and sentencing. Mr. Hazeltine has completed the IDIP program. Mr. White, is this proceeding as such?
Yes, it is, Your Honor.
All right. Plea questionnaire waiver of rights form.
Yes, I have that.
Has he had 48 consecutive hours?
Yes, he has, Your Honor. I believe it's 5 days credit from the arrest on the 10th until release on the 14th.
Can you recite the agreement for the record?
Your Honor, we have a joint agreement for a plea to the count 1, OWI as a 4th offense, merge and dismiss count 2, and it'll be the IDIP guidelines for the 0.25 or BAC or higher. That's the fine of $3,175, jail sentence 165 days, the 250 hours community service, and now that I'm not sure, I think it was the 36-month license revocation. That's not on the guidelines form or part of the negotiation, but I presume that's what would happen today, along with a waiver of the pre-sentence investigation.
Well, it's a lifetime.
I understand that. I was trying to explain that to Mr. Hazeltine, that there's a difference between what Your Honor orders and what DOT or is expected to do, especially for work release, not being able to get that until 10 years.
Yes.
Okay.
So the court, it's an OWI 4th, and I have to order a lifetime unless the Department of Motor Vehicles, there's some ways that a 4th won't be a lifetime, but they only know that because it's through their system and their things. But when it comes in front of this court, an OWI 4th, I have to order a lifetime revocation. Okay, do you understand that?
Yes, Your Honor.
And do you still wish to proceed and enter a guilty plea here today?
Yes, Your Honor.
All right. So I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes, Your Honor.
Is this the document that your attorney went over with you?
Yes, it is.
Did he essentially go over it with you word for word?
Yes, he did.
And so you understand everything on this document?
Yes, Your Honor.
If by chance you didn't understand something, did you have your attorney explain it to you until you did?
Yes.
And is that your signature on the second page?
Yes, it is.
You're pleading guilty to 1 count of OWI 4th offense. You're 37 years old, 12 plus years of schooling. You can read, write, you understand the English language. You are not receiving treatment for a mental illness or disorder, no alcohol or illegal substances. However, you have had medications. Is that all correct?
Yes, Your Honor.
And have you taken your medications as prescribed?
Yes, Your Honor.
Do your medications interfere with your ability to comprehend or understand things?
No, Your Honor.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the minimums as well as the maximum possible penalties that you face?
Yes, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of the plea questionnaire. Do you have that in front of you?
Yes, Your Honor.
Did your attorney go over your rights with you thoroughly?
Yes, Your Honor.
Do you understand them completely?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes, Your Honor.
You will no longer be able to vote in any election until your civil rights are restored. You understand that?
Yes, Your Honor.
All right. Here, the state would have to prove on or around October 10th, 2025, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. Do you understand what the state would have to prove?
Yes, Your Honor.
And this is your fourth countable offense, correct?
Correct, Your Honor.
Upon conviction of this Class H felony, you could be fined not more than $10,000 and imprisoned not more than 6 years. However, you shall be fined not less than $600 and imprisoned not more than, or not less than 60 days due to your number of convictions. Do you understand that?
Yes, Your Honor.
Do you understand that there is an agreement that's been reached for the court to follow the intoxicated driver intervention program for a blood alcohol content of 0.25 or higher?
Yes, Your Honor.
Do you understand that I'm not bound to follow that agreement and that recommendation?
Yes, Your Honor.
I could sentence you all the way to that maximum possible penalty, which could be up to 6 years of incarceration. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney? And in particular, the section, it's called the probable cause section, where it basically says what happened and why you were charged with the crimes?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you pleading guilty to an OWI fourth offense because you are guilty of that offense?
Yes, Your Honor.
Mr. White, may the court use the probable cause section of the criminal complaint with the statement made by your client to find a factual basis?
Yes, you may, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to the charge?
No, Your Honor.
You're doing so freely and intelligently. That means you are telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily.
Yes, Your
Has
Honor.
your attorney represented you competently?
Yes, Your Honor.
Has he answered all of your questions?
Yes, Your Honor.
Has he looked at this matter thoroughly?
Yes, Your Honor.
Has he looked at the discovery, which is the evidence and information in this case, and discussed it with you?
Yes, Your Honor.
Has he discussed with you a potential for any legal defenses or a lack of defenses in this case?
No, Your Honor.
What?
I'm sorry, what was the question?
Has he discussed with you any defenses that you may have? If this goes to trial, we can say this as a defense.
Yes.
And has he discussed with you a potential for no defenses?
Yes, Your Honor.
Are you satisfied with the services?
Yes, Your Honor.
Any questions for the court or for your attorney before I proceed?
No, Your Honor.
Has anyone made any, maybe I asked, any threats or promises to you for you to plead guilty?
No, Your Honor.
You're doing so freely, intelligently, and voluntarily with a full understanding of what you're doing here today?
Yes, Your Honor.
So no questions for the court or for your attorney?
I did have one question. So, I am having, a baby in September, and I was wondering if it would be possible to be at the hospital during my, monitoring.
What you will need to do at that time is you'll be talking with Miss Anderson,
Okay,
and or Mr. Hatch about that. And then you'll just write a letter to the court and you'll let me know when it comes closer to that time.
okay,
Okay.
okay,
And that's something that the court would strongly consider allowing you to do because it's the birth of a child. But we'll see what happens from now to then, okay?
Okay,
All right.
thank you.
Any other questions?
No, Your Honor.
All right. Then as to OWI fourth offense, count 1, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'll find that you understand your constitutional rights and what it means to waive and give up your rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1, OWI fourth. Count 2 will be dismissed and merged in with count 1. A judgment of conviction will be entered today. Before we get to arguments, Mr. Hazeltine, did your attorney go over with you that you can convert the 250 community service hours to extra jail days or monitor days?
Yes, Your Honor.
Okay, so you've considered that and you would be able to let me know a possibility of what you wish to do?
Yes, Your Honor.
Okay. Mr. Schmidt, argument and sentencing recommendation, please.
Thank you. I think this person has earned the IDIP guidelines in addition to completing the program, which is confirmed by Tessa Anderson. His prior OWIs were very long ago. They were 08, 09, and 11, meaning he's already shown a very long period before it happening again, which I think cuts in his favor. So I'd ask the court to follow the recommendation. Thank you.
All right, Mr. White.
Your Honor, I'd ask you to follow our recommendation here, as the prosecutor stated, and we can see with the IDIP completion form that Ms. Anderson filed in this case. Mr. Hazeltine has completed the monthly appointments, random drug tests, the AODA assessment, victim impact panel, and community service, at least what he was required to do ahead of time. He's been following the rules. He's been on bond for quite some time now. No new issues. For protection of the public and severity of the charge, I think that all goes towards this IDIP recommendation. Just for his character and rehabilitative needs, my client is, I think, moving towards a lot more serious position in his life. He's having a child that's due in the fall. He's also informed me that he's been promoted at work to, I believe, a management position. That just implies some trust and responsibility on his part. I see 2 people here. I did not speak with them, but I believe that his parents are here in support. It shows just that he does have some help. And I think that upon release from the jail and monitor program, hoping that won't see him again in court. Thank you, Judge.
Thank you. Mr. Hazeltine, anything you want to add, you want to tell me?
No, Your Honor.
Okay. OWIs are serious, and OWI fourth is extremely serious. As you can tell, not only has the legislature increased it from a misdemeanor up to a felony now in the last few years, but they have also included a lifetime restriction from driving, lifetime revocation from driving, except for in 10 years, if you do this, that, and the other, and the Department of Motor Vehicles believes that you qualify or they think that you're good enough, they would give you an occupational license at that time, but you can't ask before 10 years. It's serious. You put your life at risk. You put other people's lives at risk, and definitely not safe to do. It sounds like you are getting your life in place and on the right track. It sounds like you're doing well in your job and you're improving there, and you're going to be a father, and there's all kinds of positive things in your future. Hopefully that's going to be enough to keep you on the straight and narrow. I think that the agreement is appropriate, so the court will follow the agreement. $3,175 in fines and fees, 165 days of jail, 250 hours of community service. Before I get to the rest, have you considered, do you wish to do the community service or have it converted to additional jail days?
I would have it converted.
You would like to do that?
Yes, Your Honor. I work like 45-hour weeks, and I
It makes
live
sense.
like an hour away, so there's
I'm
not a
fine
whole
with
lot of
that.
extra time.
That's why I give the option.
Yep, thank
So
you.
it'll be a total of 197 days of jail without having the community service requirement, lifetime revocation of your driver's license. And this is where I'm unsure, Mr. White, if I'm supposed to order the AODA assessment and the driver safety plan.
So this is, I think, what Attorney White was hinting at. The court isn't actually an entity authorized to revoke a license for life. The court
Well-
is only allowed to revoke his license between 2 and 3 years. It's that once DOT receives record of this revocation, DOT has the authority to revoke for life. I
Okay,
give you the statutory citations for that if that's needed.
well, that's fine. I don't know what I'm supposed to do or what I'm not supposed to do because they
We're asking
don't
for
give
a
us,
We're asking for a
idea.
3-year license revocation, which is the maximum of what court can do under 343.30 sub 1Q sub B sub 4. And then the court, can warn people that as a collateral consequence, DOT will revoke their license for life under 343.31 sub 1M sub B.
all right, so 3 years revocation of driver's license, 3 years ignition interlock device. OWI assessment and driver safety plan. Then that means I have to order it and then you have to do it and it could be a violation if you don't. Take it up with the legislature. You do have $3,500 cash for your bail bond. So plus there's a $10 blood draw fee, so I have to do that. So you should be all paid. Oh, no, you shouldn't be. The remaining amount of money can be transferred to the electronic monitor program to help pay because you have to pay at least 30 days in advance. I'm
Okay.
going to tell you, you can't pay late. It has to be paid on time. Otherwise, you do have to go sit the time in jail. It has to be 30 days in advance. Or you can pay it off all in full at that time. When you're on the monitor, you may not have any, don't be around any rubbing alcohol, don't have your monitor around gasoline or anything that could set it off, that it has been or is near alcohol, because it will do 24/7 testing of your sweat on your skin. I've not been shown, proven or disproven that if it's around rubbing alcohol or things like that or touches it, that it sets it off. If it does set it off and indicate that there has been alcohol or that there has been a detection of alcohol, you will be told that you must immediately go to the jail and you're going to be revoked from the monitor. No good time, no Huber. Very important that you do those things. I would not eat anything that is made with alcohol, such as chicken marsala that uses red wine and those kinds of things that could still set off the monitor. So be very careful, okay? And probably don't use mouthwash because some is made with alcohol, okay? Rubbing, whatever alcohol that is, because that could set it off. I don't know if it will for sure. I have not tested it, but I just want to make sure that you know to avoid those things for this amount of time because you don't get a due process hearing or there's no kind of hearing that you get to say to the judge, I didn't do it. I promise it wasn't me. It was something else. Okay.
Okay.
You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The rest of the money will be transferred to either Tessa Anderson or Dave Hatch for helping pay off the monitor. I need to order your DNA. You need to provide that to the jail. You're going to go get booked in today and you're going to provide your DNA. You have the right to request it be expunged through a written letter to the Department of Justice. So go ahead and do that. And then follow all the rules and procedures for the monitor. You can have Huber release, go to work. You can go to doctor's appointments. You can go to AA. But if there's anything else that you need to do or that comes up like a funeral, you can't go unless you ask for the court's permission. And I don't always grant it for things. So it's better to make sure and hopefully have your life planned out already. I think that covers everything, Mr. Schmidt.
Nothing from me.
Okay, Mr. White.
As long as the sentence credit was noted, I think that was everything.
5 days. Yep, 5 days sentence credit.
Okay.
Thank you. Then we are adjourned. Why didn't you bring that up like 4 years ago when it changed and I have to say the things, Mr. Schmidt? It's been 4 years.
I mean, you should say it just like you should say like immigration consequences, but you don't order people deported.
Lifetime? A lifetime revocation?
Yeah.
I always say it on OW 4-5. No one's ever said anything different.
Oh, I just didn't notice.
We're told to say it.
I mean, you should say it. It's important collateral consequence. I bet a person could withdraw a plea if they didn't know it.
All righty. You can take my pen.
About it, but, oh, thank you. But yeah, I don't see it. I didn't see it in anyone's review files. I didn't see it anywhere, so I don't know.
Interesting. All righty. Mr. Beechler, come on up. Oh my gosh, my voice is not going to handle this. Attorney Kevin Schmidt in person. Mr. Beechler appears in person with his counsel Joel Feliski. We do not have any victims apparently wanting to appear today, correct, Ms. Bauer?
I don't see any.
But you're in victims' rights compliance?
Yes, Your Honor.
All right. So the parties have reached an agreement. Mr. Feliski, can you please recite it for the record?
Yes, Your Honor. The parties have reached an agreement here for Mr. Beechler to plead to count 1 in 25 CF 158 as amended to a misdemeanor OWI second, with count 2 being dismissed by operation of law. The parties will be making a joint recommendation for sentencing under the aggravated guidelines. My understanding of that being $1,711.50 in fines and fees, a 45-day jail sentence, a 17-month revocation of license, a requirement for an ignition interlock device to be installed in any vehicle operated by Mr. Beechler, along with a 45-day occupational wait period. I have reviewed and completed a plea questionnaire detailing this with Mr. Beechler. Your Honor, may I approach?
Okay. How many days jail did you say?
45 days.
It's aggravated guidelines.
I know, but I have blood alcohol content of 0.16, not 2.022 or 2.249. And if we do 0.16, it's 40 days jail, 16 months revocation. Tenth District Judicial District Guidelines for an OWI second, 0.16 or over 0.15 aggravated.
I must have just misaligned the lines when I did it. It's one higher, so it should be 40 instead of 45 days and 16 month. Oh, I'm sorry, wrong category. Yeah, 40 instead of 45 and 16 instead of 17 for the revocation.
Sounds like a better deal for you, Mr. Beechler. All right. That's the agreement you've reached, Mr. Beechler?
Yes.
May you please turn the microphone down? Thank you. Pleading guilty to an amended count of an OWI operating while intoxicated second offense. Is that correct?
Yes.
Formal motion to amend the OWI causing injury second and subsequent to a straight OWI second.
So made.
Granted. You're 37 years old. You have 11 years of schooling. You do not have a high school diploma or equivalent, but you can read, write, and you understand the English language, correct?
Yes.
Did your attorney go over this document with you?
Yes.
Did he go over it thoroughly with you?
Yes.
Essentially word for word?
Yes.
Did you understand everything completely?
Yes.
If there was something you did not understand, did you ask him to explain it to you until you did so?
Yeah.
Is that your signature on the second page?
Yes.
You are pleading guilty to that OWI fourth count. Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of those rights is listed on that first page of the plea questionnaire. Did your attorney go over those rights with you?
Yes.
And he went over them thoroughly with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over those rights with you in any more detail?
No.
Do you understand that you're giving up those rights by pleading guilty?
Yes.
No mental illnesses or disorders, no alcohol, drugs, or medications in the last 24 hours?
No.
Because, do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that the state would have to prove on or around November 2nd, 2025, that you operated a motor vehicle while under the influence of an intoxicant on a roadway or a highway of this county and state? Do you understand what the state would have to prove?
Yes.
You understand that this would be your second countable offense?
Yes.
You understand the minimum and maximum possible penalties? The minimum could be minimum of 5 days of jail, but no more than 5 days of jail is the minimum. 6 months of jail is the maximum possible penalty. Do you understand that?
Yes.
Or a fine not less than $250, but no more than $1,000. Do you understand that?
Yes.
Do you understand that the court is not bound to follow the recommendation that's been provided through argument or recommendation from the parties? Do you understand I'm free to sentence you to what I believe is appropriate, and that could be up to the maximum possible penalty?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney? And in particular, I'm going to say that probable cause section where it basically says what happened and why you were charged with the crimes.
Yeah.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty today because you are in fact guilty of that offense?
Yes.
Mr. Felisky, may the court use the probable cause section of the criminal complaint to find a factual basis with the statement made by Mr. Beechler?
So stipulated.
Has anybody made any threats or any promises to you for you to plead guilty today?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he answered all of your questions?
Yes.
Has he looked at this matter thoroughly?
Yes.
Are you satisfied with his services?
I am.
Do you have any questions for the court or for your attorney before I proceed?
No, I do not.
As to count 1, OWI second, straight offense, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'll find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged in and dismissed. A judgment of conviction will be entered today. Is there, I forget if there's restitution, and there may be, that was settled with the insurance?
There's no restitution request. We checked with the victim. They did not want there to be a restitution request because in consultation with their attorney, they thought it might negatively affect how they get that somehow.
All right, I think I recall that's what you said at the last hearing. Okay, so Mr. Schmidt, argument and sentencing recommendation.
I'd ask the court to follow this recommendation. The defendant, his only prior history is his other OWI from 2021 in Mesa, Arizona. This is a case where the victim, his worst injuries were caused by being dragged under the defendant's car. According to the victim, he doesn't remember much. He just remembers that he had to be removed from underneath the car with assistance of first aid responders and had pretty horrific injuries. That's kind of detailed in the victim impact statement. The defendant, his account was something like, he doesn't know how the victim got under there. He just did somehow. There was a witness at the bar where the victim was struck by the side of the road. He said that there was a second vehicle that first struck the victim, and then the victim got thrown underneath the vehicle of Mr. Beechler. Mr. Beechler did stop his car and get aid immediately. He also, while he was in custody, everything law enforcement went to him for like getting consent and looking at like phones, vehicle, etc., to try to find evidence of the second vehicle or locate who it was. He was aiding in that. We never did find the second vehicle. It's hard to say how much of this is Mr. Beechler's fault and how much of this is the first vehicle's fault. Mr. Beechler did do a good thing in when he did collide with someone to call the police and get that person help. On the other hand, Mr. Beechler was intoxicated and he shouldn't have been behind a motor vehicle and somebody did get harmed. Is it possible that even with those circumstances that this victim wouldn't have been harmed if Mr. Beechler was intoxicated? There are just things we'll never know in this case. So for that reason, I think the aggravated guidelines are appropriate and I'd ask the court to follow them. Thank you.
All right, thank you. Mr. Felisky?
Thank you, Your Honor. I will first note the applicable credit here. Mr. Beechler appears to have 32 days of credit. He was brought into custody on this offense on November 2nd, 2025, and was able to post cash and was released on December 3rd of that same year.
It was already set the time. It's good time. Sorry, I didn't mean.
Oh, I'm just reflecting on what I'd like to say, and I think I'll start out by saying that I grew up with alcoholism in my home. And I think that the thing people miss about alcohol in that regard is that it isn't just the physical harm, the mental unwellness, the behavioral changes that really impacts people. They do play a role. But when I was thinking about this case, the thing I was struck by was that when it comes to alcohol and alcoholism, for the individual that's suffering from that, it's a question of misery. It's someone who takes all the gifts that their parents give them, all the love and care their friends and family and community can provide them, and they drown it. They drown it in alcohol. They let misery win. And in my life, it kept winning and winning. And one day that person made a decision not to let it win anymore. And by that time, for some things, it was too late. But that was what made the difference. And sitting here today and speaking with Mr. Beechler and having spoken with him with this case as it's proceeded, I know that he has made the decision not to let misery win. He made that decision, as the state noted, perhaps from the get-go. He took accountability immediately. He got out of his car. He called law enforcement, knowing that they were going to be there, that he would likely be going into custody, that things would get very difficult for him. He made the decision to not let misery win when accepting responsibility here, when taking this offer from the state, when accepting up until, as the court noted, the aggravating factors, additional time in custody, taking accountability for having committed an OWI, taking accountability and responsibility for committing that sort of action by having his license revoked, by requiring an IID in his vehicle. he's taken accountability and responsibility here and has not let misery win by dwelling on this, by thinking on it and reflecting it. One of the most notable things I found about Mr. Beechler has been the degree of devastation and regret and contrition that he has shown stemming from this incident. It has truly devastated him. And in some ways, I think that's healthy. I think a terrible thing happened that night. And while Mr. Beechler perhaps was not the cause of all that happened, he is here and is ready and is willing to admit his part in what happened. In the time since this has happened, he has continued to not let misery win by working on getting his HSAD in the jail. I believe he's waiting for some paperwork to finalize and finish that process. He's been working on getting custody back for his son, and following the proceedings here today, following the resolution of this case, he does plan to return back to Arizona to continue seeking that custody. I think looking at the galleon factors here, Your Honor, this agreement is appropriate. It protects the community. The community has been and will continue to be protected by these deterrents, by these requirements that Mr. Beechler will be required to follow through on. I think it's appropriate given the nature and gravity of what happened here. And I think looking at his character, perhaps most importantly, Your Honor, I believe this experience has truly changed him. It's regrettable that this is what it took, but it has changed him, and in some ways it's changed him for the better. He's been able to refocus on what truly matters, which is his family. He's kept himself busy and occupied through employment at 2 different jobs. He has been working on his hobbies, finding better ways to express himself and to work through stress without drinking alcohol and getting behind the wheel of a vehicle. And perhaps the other thing that has really struck me about Mr. Beechler is his focus on the victim. Every opportunity that it has come up, every time it has been mentioned in our conversations, he's expressed nothing but regret and shame for what happened. In fact, several of the first times that we met and spoke together, he started out by asking, is he okay? How is he doing? I think that says quite a lot about his character. I think that says a lot about how he has thought about this process and what happened overall. And I think that it is very indicative that this is not going to happen again. Overall, I think under the galleon factors here, I do think that this agreement is appropriate, and I would ask the court to follow it. Thank you.
Thank you. Mr. Beechler, is there anything you want to add or you want to say to the court?
Excuse me. I know that Jackson and his family aren't here, but I wanted to take accountability for the decisions that I made and tell them that I'm deeply sorry for the pain and trauma that I've caused them. And that I'm going to do everything that I can to make sure this mistake doesn't happen again. Thank you.
Right. That was a very profound and touching argument, Mr. Flisky.
Thank you, Your Honor.
Operating while intoxicated cases are very serious, and in this case, you can see why. Mr. Beechler, this was a case where you were over the legal limit, twice over the legal limit. You were operating a motor vehicle, not just operating, you were driving on a road or highway of the state and county, and you hit a human, and the human was seriously injured. On the other side, You were the second car to hit that human. Had the first car not hit Jackson, perhaps you would not have hit Jackson either. There's no way to tell. If we could go back in time and we can change some things, I know we would. But there's, as Mr. Schmidt stated, there's no way to determine the percentage of your fault in Jackson's injuries or the phantom car who was never caught, their fault in Jackson's injuries. But everybody does agree there was another vehicle. They just weren't able to determine who it was that was driving that vehicle or the vehicle itself. But you're standing up and you're taking responsibility and you're being accountable for your actions, which is a positive thing. Not easy to plead guilty to a crime. And it's definitely not easy to plead guilty to an operated while intoxicated offense. Because in the state of Wisconsin, once you get your 4th lifetime revocation of your driver's license. And that's a big deal. When you live up here, you live where we do in Wisconsin, you need a driver's license. It's very difficult to be dependent upon another person or other persons to be able to get you anywhere you need to go. It's, nobody says otherwise that this is a serious offense. Hopefully you're doing better and you understand things better and you're going to do things differently the next time. At this point, you don't seem a risk to the community. I don't have any bail jump violations. This goes back to November 2nd of 2025. I have no indication that you are breaking the law or doing some things and not understanding the seriousness of your conduct that day. It's a positive thing, and it's a good thing that I heard you say, my mistake, the mistake, instead of the accident, or it was an accident. It was not an accident. Did you intentionally mean to hit Jackson? No, but you intentionally got into a vehicle while under the influence of an intoxicant, of alcohol. That was intentional. You knew what you were doing there. It had serious ramifications, more serious than any some normal run-of-the-mill OWI, but it wasn't an accident that you operated while intoxicated. I believe that you've shown the court that you've been doing a lot to improve yourself, to educate yourself, to have some personal reflection, and to take accountability. So the court will follow the recommendation of the parties at the above 0.15 blood alcohol and aggravated driving. $1,680 in fines and fees with a $10 blood draw fee, 40 days of jail, 16 months of revocation of your driver's license, 16 months of ignition interlock device installed in your vehicle. I will order the OWI, AODA assessment, and all of the follow-through. I will also give you credit for any administrative suspension that you may have already received. You have 32 days of jail credit, and you sat that all up front, and you got a huge penalty in the beginning when you were arrested. You had plenty of time to think about your actions and the consequences of your actions while you were incarcerated. With good time, you do not have any other time to sit. We do have significant cash posted for you. The fines, fees, all of that will be taken out of the cash bail. The remaining will be returned to whoever posted it. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I am going to order that you provide your DNA. So you're going to need to go to the jail when we're done here today to ensure that they have your DNA. You have the right to request it be expunged from the system through a written letter to the Wisconsin Department of Justice, not to this court, to the Wisconsin Department of Justice. It's easy to do. You can Google it or ask Mr. Flisky. He can help you if that's what you want to do. I believe That covers everything. Mr. Schmidt, what am I missing?
Nothing from me.
Mr. Felicity.
Nothing further.
All right, thank you. Then we are adjourned. You need to come up here and get a form to go to the jail.
Hey, Your Honor, I'm going to go grab Mr. Java. I have him at the office. I had to meet with him anyway today. Give me just 1 second and I'll be right back.
No problem. Thank you.
Yep. Much have you baked them, but if they need to see you to verify that you use it, we will figure that out. Give me 1 second. Okay. There we go.
All right, is he with you now?
Yes, do you want me to just have him pop back so you can see him quick?
Yeah, yes, or scoot
Okay.
closer to you so I can see both of you.
Okay. Yeah, you can pull it up right there. It's totally fine. I'm just gonna minimize everything else. There we go.
All right, we will go on the record in the matter 24 CT 30, State of Wisconsin versus Ethan Java. The state appears through, well, we don't have the state, well, we do through probation agent. What's your full name?
Abby, Abbie, last name Ausen, Aasen.
Thank you so much. This is the first time I've interacted with you, Ms. Austin, so thank you very much. And thank you for spelling it for the record for my court reporter.
Yeah,
We're
no
here
worries.
today for a probation review hearing at the request of Ms. Austin. Mr. Java appears in the same office by video conferencing with his agent, Austin. Ms. Austin, you requested this probation review hearing, and I'm going to be honest, I don't know why, because I don't have a letter in my file. I don't know why it was requested.
Sure, my apologies. Moving forward, I will send a memo up to Burnett County. I haven't really dealt with Burnett in really any other context. And normally I don't send memos to my court unless I'm requesting something with an order. So I just called this probation review hearing. Mr. Java has truthfully been a great client to work with. I haven't really had any issues with him. He's had no violations in the past year. The only thing is that he does not have his driver safety assessment and follow through complete. I know that he's maintained meaningful employment. He's been able to move out of his brother's into an apartment style living, which has been more beneficial to him. He's able to split rent, stuff like that. But with obviously living in a more expensive area, and combined with making payments to the court, which I don't think is a bad thing, finances are tight. Our assessments here, just the assessment alone is, I think, a little over 300.
Long and the short, you're going to ask to allow him to discharge without having to do that, correct? Is that where we're going?
No, I was going to ask if he could be extended. I just wasn't sure in what increment you guys would want him to be extended in, whether that's 6 months or a year, and if the court would allow him to pause on his payments just to get the money to do his assessment.
All right, that makes me feel better, Miss Austin. Sorry, and that's why I like memos. I don't know what they do in Pierce County or other counties that you appear in front of. I like a memo so I can be prepared to have an idea of what you're asking for and why you want the hearing. Because quite honestly, I'm like, okay, what has Mr. Java done? Has he driven now without his driver's license? Those things. That's all good to hear, Mr. Java. That makes me so proud of you.
Thank you.
Because I want him to get his driver's license. I'm going to be quite honest. I was getting sick of seeing his face in my courtroom.
Fair
And
enough.
that's in a funny way. Yes. Because he would come here and then he would leave, he'd post bail, and then he'd go and he'd drive again and he'd be back here and he'd post bail and he'd do the same thing. I want him to get his driver's license. And I know he wants to do that as well. So I am comfortable. I don't care if we extend for a year, we extend for 6 months. And my thought is as soon as he gets his driver's license, I'm okay with him discharging immediately. I want him to get his driver's license.
Okay.
So if you want to just extend for 6 months and see if he can do it within 6 months, that's great. You want to extend for a year and have in there that the court stated that I'm only extending it to as long as until he gets his driver's license. I'm cool with that too. I want him to get his driver's license. I am also prepared to I'll give him a few months of stay of payments for his fines and fees. Because to me, that's worth it for him to be able to pay for his OWI AODA assessment and do all of that follow through and to pay to reinstate his license and the ignition interlock device and all of those things. So I will give him a stay until September. First payment back will be September.
Okay.
And if we need longer, if you need any longer, Miss Austin, I don't need to have a probation review hearing to be able to do that. All I need is a memo that lets me know he's been doing what he needs to do. He's been able to save some money. He just isn't yet able to get his license. Can he have a stay for a couple more months? Something along that lines. And then I can just stamp it and go, yep, I agree. I don't see why I wouldn't agree. But if I didn't agree, I'd just say, nope, denied for whatever reason I find to deny. But I'm all with you, Miss Austin. And I'm all with Mr. Java. I want him to get his license as quickly as he practically can.
Perfect. I will submit the 37A and I'll put on there with acquisition of driver's license. Cause I mean, realistically, the assessment and the follow through are going to have to be done anyway for him to get his license. So yeah, I'll prepare that order. Is there anything else that you would need from me for the court?
I don't think so. Is he paying, you're paying, Mr. Java, you're paying the court fines and fees and payments here, or you're just paying DOC?
I believe I'm sending them to Burnett County.
Yes.
Collection, so that's weird.
Well, my clerk is saying that we're seeing that you're in our state debt collection. So are you making payments every month?
I haven't missed, or I missed last month, but if I'm in the debt collections thing, that would explain it. Is that like wage garnishment or?
It could be, and I'm not in control of that. What I would need to do then is talk to my court clerk, my head clerk, and see if we can pull it back from state debt, because it sounds like you already have an agreement and you work things out with state debt collection. And if you're making payments and you missed one, you're paying the state debt collection, not to the court. And so what I can do is I can double check on that. And if we can pull you back, I'll pull you back, and then I can stay you until September and we can go from there.
Okay.
But then I'm going to tell you, I'm trial date. Can't get involved in negotiations, but didn't you do a deferred on one of those cases that was similar?
I don't think so.
Deferred judgment of conviction. Yes, it was with the Renee Landgraf case, the guy who is up, who had a lot of intent to deliver methamphetamine in Ashland County, Ryan something.
It's not ringing any bells for me.
Then maybe it was the Mr. Valet matter. I can tell you his girlfriend's name. I can't tell you his name. I don't know why. Alrighty. Okay. First name's Ryan.
I'm not saying it didn't happen.
Yeah,
It's
I
not ringing
just
a
can't
bell.
remember his name. I'll remove the trial for the 23rd. But I can't put him in until July 13th.
Is that okay with you, Mr. Woolman? July 13th?
Yeah, I think so.
If you're able to get your license before then, if he is the offer still on the table?
Yes.
What does he still have to do to get his license?
Like all the same stuff, SR22 and the classes and
Gotta push really hard,
Interlock.
Mr. Wellman. Push super duper hard, okay? Because these are getting old, 657 or 47 or whatever days old. If you can get your license by then, the state will keep the offer open, okay? July 13th at 2:30.
That works for the defense.
All right, thank you. We will see you then. You can come get your notice and you're free to go.
Thank you.
Mr. Lubick, can you hear me?
Yes, I can.
We will go on the record in the matter 24 CT 101, State of Wisconsin versus Jacob Lubick. The state appears through District Attorney Kevin Schmidt in person. Mr. Lubick appears by video conferencing capability with approval of the court. We're set here today in this matter for a status conference. Mr. Lubick, can you please update the court? Where are you in the process of getting your license?
I got my permit. I just have to take my actual driver's test. Unfortunately, as soon as I got my permit, our engine in our vehicle broke down. That's not the worst of it. The shop that was working on my vehicle burnt down. So it is the hope
Put that on the record.
It is the hope of the mechanic that the insurance company will cover the cost of the vehicle. It's absolutely insane.
It was a blue moon yesterday, so that counts as all of the month as having super much fun. Okay, Mr. Lubick. Your case is 538 days old. What do you, so can you borrow a car to take your license?
It has to have an interlock device on it in order for me to take the test. Otherwise I would be able to get it, but I don't have the interlock device on any other vehicle.
Insurance, when it relates to a fire, generally takes a significant amount of time to resolve. Are you saving money, or do you have any money saved to try and look and buy another vehicle?
We've been looking for the past 3 weeks.
And what have you been looking on? Car Gurus?
We've been looking everywhere just to get a cheap junker that I could get an interlock on. Family, friends, we've tried everybody. I honestly don't know where we're at with that yet. We do have another vehicle that is broken down that needs a timing chain fixed. So we may go that route, but
that sounds perfect route to me.
We're trying.
So you need to pass the driving test, you need your SR22 insurance. Nope. As well as the oh no, you're right. You didn't need that insurance for whatever reason, some weird reason, right?
Yeah, all I need to do is take the test and I have my license.
And right. So that's all we need to worry about is you taking the test. Yeah. And once you get your license, this is dismissed and you can worry about the ignition interlock device later. Why don't you just borrow a car? Take your driving test.
They say I can't take the test unless it's with a car that has an interlock device.
Oh, they're saying that. Son of a nutcracker.
Otherwise, I would have had my license months ago.
Look into the timing belt, please. Please. That's cheaper than buying a car. And if a timing belt fixes it enough so you can drive it, that's awesome and amazing in many different ways.
The shop wants $3,000 for the installation of a new timing chain.
Well, then I wouldn't go that route.
Yeah, so we've been trying to do everything we can. I'm just praying for some luck.
I'll pray right there for you. July 13th at 3 o'clock. I don't know what to set you for. I'm going to set you for well, it doesn't need to be a plea in sentencing if you get your license, and that's what I'm hoping for.
Okay.
You got to work hard, Mr. Lubick. You're not my oldest OAR case, but you are pretty old. And I am a numbers person, and I look at numbers because the numbers and the age of the case affects my statistics, and I don't like to be slowed down. But number one is you getting your license, quite honestly, and I really want you to. So try super, super hard, the hardest you've tried in a long time, okay?
Yes, Your Honor.
All right, thank you.
Thank you.
We're adjourned. Ms. LeBeau, we will go on the record in the matter 25 CF 130, State of Wisconsin versus Sheila LeBeau. Ms. LeBeau appears in person, or excuse me, by video conferencing. Her attorney, Nicholas White, appears by video conferencing capability. We're set today in this matter for a status conference. Mr. White, can you please update the court? Have these matters completely resolved in Polk County yet?
Yes, they have, Your Honor. They were resolved on May 21st. Ms. LeBeau entered a guilty plea there and was sentenced. I believe the prosecutor in Burnett has received my email of the judgment of conviction, but I was unable to file that from Polk County. CCAP denied the file because it had information from the clerk's office. So otherwise, it's been negotiated there.
And for the record, because I am all out there and open and honest, Judge Tolan did call me to see if this was an agreement that's been presented to me, and if I was okay with it. I said yes.
Okay.
So we just need to get the paperwork done or all the things done. Mr. Schmidt, you just want to dismiss, or is this a DRI? If it's a DRI, it's going to require lots of paperwork.
I don't actually know because it's Jose's case. I see looking at Protect, he's writing something now to file. So if you just want to set like a dummy status 1 week out.
Okay.
Sorry.
Mr. White, I'm just going to set it for July 20th at 10:30. Hopefully everything's done and we get that filing from from Mr. Valet, blah, 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 lard. And then, sorry, it's been a blue moon kind of month. So once we get that, we should be good to go. I'll sign it. We're good to go, and we won't need to appear at that hearing. I just need to cross the T's and dot the I's kind of thing, okay?
Okay, understood.
All right, thank you. We are adjourned.
All right, thank you,
My
Judge.
voice is giving out. Thank you.
All right, take care of yourself.
Mr. Mason? We will go on the record in the matter 26 CM 48, State of Wisconsin versus Cody Mason. The state appears through District Attorney Kevin Schmidt in person. Mr. Mason appears in person with his counsel, Joel Flisky. We're set today in this matter for a bond modification request and a status conference. Mr. Flisky, please update the court.
Thank you, Your Honor. I think we can focus attention here today on the bond modification primarily. The state did make an offer to me that I would like to discuss with them and need to do some additional negotiation for. But setting that aside, I think the request for the bond modification here is fairly straightforward. From my notes from the initial appearance here, it's my understanding that if Mr. Mason were to successfully complete the domestic violence course with Dave Hatch, the court would be willing to consider allowing for no violent or abusive contact with his 4 children. He has successfully completed that course, and it's my understanding Mr. Hatch has filed proof of that In the file here, I'd additionally note that Mr. Mason has been working full-time and working quite hard. He reports working 7 days a week at Adventurous Pubs, and by June 5th, we'll actually have enough money saved to get his own apartment and place to stay. The only other thing I would note is that he does have his children's birthdays coming up in June and July. So at this time, I would ask, considering all this, for Mr. Mason to have his bond modified and allow no violent or abusive contact with his children. Thank you.
Victims' rights compliance.
Yes, Your Honor. The victim indicates she wants a no contact to continue to exist with her. She still does not want to have contact with him. She's fine with him having contact with the kids. It's good for them. She does not want to be dropping the kids off with him. So state doesn't have any objections to requests so long as there's, I know the court knows more about like family court stuff, how to facilitate getting the kids to move around. That we didn't get much input from the victim.
Well, how am I supposed to have contact with my kids if she doesn't ever answer?
Well, and that's the thing. I don't think we have a restraining order or an injunction. It would be a third party you would have to contact, so there would need to be a mutual third party. Either you can have the third party or she can have the third party. I will amend the bond condition to say still no contact with Ms. Mason, no abusive contact with your 4 children or the residents. Facilitation for any time with the children, any visitation or visits with the children shall be made through a third party. Do you have somebody that you know, Miss Mason? Does she like your mom? Does she like your dad? Does she like your friend?
I mean, I could try to have my sister contact her, but to what I acknowledge is that's going to be a difficult one. Can you lift where I can at least stop in the parking lot if I see my kids out by the road and say hi to them? I mean, I don't go past the parking lot. I refuse to walk up to that door after I find out who she's been having around there.
Really
But
can't do
that's
that.
that. So,
You really got to stay away from the parking lot.
well, I've been staying away from there completely, ma'am. I mean, so I like to just see my kids. Their birthdays.
I get that. I don't know. I don't believe I have a family case yet.
I understand.
I do not have a family case. I can't make any decision as it relates to any custody or placement
I know.
in a criminal matter. All I can say is that you can have contact with your children, but through a third party has to make the arrangements.
Okay.
And apparently the arrangements mean where they're going to be dropped off or picked up, and because Ms. Mason doesn't want to have any contact with you.
Understand.
So
Third party.
I'm just going to say third party because I don't know who she's going to like or not like or talk to or not talk to. All I can say is that's what I can say because again, I have no family case in front of me. And so how long do you need to talk to him about the offer, Mr. Flisky?
Your Honor, I think a status in the normal course of business would be appropriate.
I need to clarify. Defense counsel, Ms. Roseland appears by telephone conference with approval of the court. We're set here today in this matter for an arraignment. Mr. Harrington, were you able to go over the criminal information with Ms. Roseland?
I was. She understands the charges. She understands the maximum penalties, not guilty plea as to all 4 counts. This is already scheduled for a status on July 9th. Mr. Schmidt and I have been discussing resolving this, and I really think we'll get it resolved.
All right, thank you. We will keep the July 9th date. Not guilty pleas will be entered on her behalf on all matters. She is entitled to a jury trial, would be entitled to a speedy trial should she request one. Ms. Roseland, you are going to be paying your down payment on June 3rd because that is when your payday is. And so I've extended that. So just make sure that gets paid, okay?
Okay.
And stay in contact with your attorney, all right?
All right.
All right, thank you. We're adjourned.
Thank you.
We will go on the record in the matter 25 CM 120, 26 CM 15, 26 CM 47, 26 CM 67. State of Wisconsin versus Evan Harmon. The state appears through District Attorney Kevin Schmidt in person. Mr. Harmon appears by video conferencing in custody in Burnett County Jail. His counsel Eugene Harrington appears in person. We're set today in these matters for a status/bond modification hearing request. Mr. Harrington, please update the court and let me know what you're asking as it relates to bail bond.
Request the bail be amended to $1,500 signature bond with the same conditions. He doesn't have the cash to satisfy those conditions. He's paid some money before in the other cases. He's reasonably confident that he gets out of jail, he can become employed through express staffing at the Boudre Company in Frederick. He will live with his grandmother. I have chatted with her and she affirmed that he is welcome there, provided he keeps his nose clean. He doesn't have any charges pending anywhere else. Paragraph 5 of my form, I include that he'll waive extradition. He doesn't have cases pending in Minnesota. I should probably have taken that out. We have received a plea proposal from the district attorney whereby Mr. Schmidt proposes that Evan plead to OWI 2, $1,680, 40 days in jail, 16-month revocation IID, and then 1 year probation driver safety plan. I chatted briefly with Evan in the jail. I didn't have the particulars in front of me, but I'll talk to him again. I really suspect that this case will be resolved. I think we're scheduled for another hearing date, perhaps not.
I don't think
So you
so.
plan sentencing on 6/15?
Oh, yeah, plea and sentencing on June 15th, that one. Mr. Schmidt, argument?
The court knows him very well. He's been in Burnett a long time. The main concern is he just seems kind of out of control right now. I believe he already has 1,500 posted, which the court graciously did not revoke. I wouldn't object to, reducing the 2,500, the new higher cash bond to something lower, as long as it's at least that 1,500 still. He does need skin in the game.
All right. In reviewing the totality of the cases in front of the court, which are now four open cases in this court, seeing that they stem from July 7th, 2025, December 27, 2025, March 28, 2026, and then May 2nd, 2026. It's seeming that every few months, unfortunately, Mr. Harmon is not behaving well and has been brought back into custody. And he currently has a bail bond on all four matters together with that $1,500 cash. Well, it would have been more if he would have paid the $2,500. I'm willing to give him a chance, but honestly, he does need, I need to not only know that he's going to appear for court, I need to know that he's going to abide by the court's conditions. And if $1,500 is not enough to continue to do that, then I am going to order $1,700 total. So another $200 to post. Mr. Harmon, it's very important that if you're able to post and get bailed out of jail, that you follow the law and the bail conditions to the letter and to the T. 969.13 of the Wisconsin statute says that the court shall revoke your bail or shall forfeit your bail if you violate the bail bond conditions, and committing new crimes or allegedly that rise to probable cause and arrest could be a forfeiture of that cash, and I don't want to see you lose that.
Yes, ma'am. I know it is unrealized. The last 4 months have been sort of rocky for me, but I have a little one on the outside and I know.
Kevin Schmidt in person. Mr. Capuzzi appears in person. Without counsel, we're set here today in this matter for a status conference. Mr. Capuzzi, you were in the process of getting your AODA OWI assessment and you needed a little bit more time. Where are you now in the process?
I have that is Thursday at Community Counseling Services in Chippewa Falls. That's where I have to be there. And then the other thing that has to happen, we're trying to figure out, I had a judgment from Geico Insurance for an accident that I was never in. And an address that I never lived at was but I've been, Polk County Sheriff's Department last week gave me the information that they had from the judgment, but there was no police report of the accident because they just exchanged information. Well, we found out since that it was my ex-girlfriend's boyfriend who I had given the truck to. And so that's gonna take a minute, I think, to sort out the whole thing. Cause the guy who I got in, who said I was in the accident with him, he's like, well, that's not the guy that ran into me. So that helped a lot. And that was just last week. So, but it doesn't, like the case is closed and it's the whole thing now. It's been a really hectic month and a half and I don't understand how this whole process works either.
So you're going to Chippewa Falls to get that assessment?
Yep, that's where I got the initial one, and then that's why I was told I had to go through again.
When are you gonna do that?
Thursday.
Yep,
It's paid for and everything.
And so you're fighting the judgment that wasn't due.
Yeah, but that's the other thing that's suspending my license is that unpaid judgment for an accident.
You can see that.
Yeah, it's not cool.
Where was that? That was in Polk County?
Yep, it was in Polk County. The accident itself, I guess, was in 2021. In 2023, they started the process of whatever, and then because I never lived at the address they have listed there or anything.
And Frank Fratellone versus Dan Capuzzi, 23 SC 383.
No, that's not it.
That's not it.
No, it's Progressive Insurance.
Oh, 23 SC 657. So you spoke with Polk County and what did they tell you you need to do?
Well, so when I initially called them, they only had the information about the claims, the judgment part of it, So then I called Progressive Insurance and explained to them the situation, and I gave them the case number. And then a nice man called me back, and he was explaining everything to me and what the vehicle was, and they just exchanged information and driver's license plate info and stuff at the time. And then the process of the judgment started going through, and apparently they tried mailing stuff to me, and it got returned, and there was all kinds of stuff that.
I'm printing something off for you. It is the attorney who represented Progressive when they got the judgment.
Okay.
You can perhaps call him, Mr. Cohn.
Yep.
And talk to him and explain the situation and let him know you have proof and all of those things. And maybe you can make headway through him.
Yeah, the people from Progressive were really helpful. I mean, initially they were like, well, this is a closed whatever claim and stuff. And I'm like, well, I don't know anything about it. And yeah.
All right. I am going to schedule you for another date. July 15th.
Okay.
At 10:45, July 15th, 10:45. Hopefully you'll have more information and then we'll know you'll have completed your AODA assessment, OWI assessment, and hopefully you'll know what follow through you have to do. And hopefully you'll be almost through that follow through. And then you can give me an update on this judgment, okay?
Okay.
And then we'll see where we need to go. So you can come up here, get your notice, and you'll get that letter that has the attorney information on, and maybe you can contact him too, since he was the attorney of record.
All right, thank you, Your Honor.
Kevin. United States versus Yamashita. from post-World War II. Yamashita was the Japanese general that committed atrocities in the Philippines. He was charged with murder under the United States jurisdiction, and the Supreme Court had a lot of commentary about the uniqueness of that case, and that he was arrested, I think, in Philippines or Japan after World War II, and then tried in the United States court system, convicted and executed.
All the evidence have been collected over there.
It's a long ago case. But
Yeah, I
that
found
may
it.
have something about it.
All righty, we have Mr. Butler. We will go on the record in the matter 26 CF 55, State of Wisconsin versus Gary Butler. The state appears through District Attorney Kevin Schmidt in person. We have Eugene Harrington, Defense Counsel in person. Mr. Butler appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for an initial appearance. Mr. Harrington, were you able to go over the criminal complaint with Mr. Butler?
I reviewed the charges. I reviewed the maximum penalties. I summarized the facts to him. He wishes to have a preliminary exam, waives reading, waives time limits.
All right, not guilty plea as they're both felonies, waives time limits. I could do June 18th at 3.
Works for me, Judge.
June 18th at 3 p.m. We will see you there. Thank you, Mr. Butler.
Judge,
Thank you.
And so I also want to note, this may well be a waiver. We have received an offer.
Okay,
It's just a matter of following up on a couple things.
sounds good. Thank you,
Yeah.
Ms. Butler.
Thank you. That's dismissed the felony.
Who are you here for? Oh, Ms. Songatay.
A Wisconsin courtroom saw a significant DUI sentencing as Jacob Hazeline appeared before the judge to enter a guilty plea for operating while intoxicated, 4th offense. After successfully completing the intoxicated driver intervention program, Hazeline accepted responsibility for his actions and moved forward with a negotiated plea agreement. During the hearing, the court carefully reviewed his rights, the facts of the case, and the consequences of the conviction. The judge emphasized the seriousness of a 4th OWI offense, explaining that repeat drunk driving offenses put both the driver and the public at extreme risk. Hazeline acknowledged his guilt and confirmed that he understood the penalties he faced. Prosecutors noted that his previous OWI convictions were many years old and that he had complied with program requirements, completed assessments, and remained trouble-free while on bond. His attorney highlighted positive changes in his life, including a promotion at work and the fact that he is expecting a child in the near future. Family members were also present in court to support him. The judge recognized those positive developments, but stressed that drunk driving remains a very serious crime. The court ultimately followed the plea agreement, imposing thousands of dollars in fines, a lengthy jail sentence, and strict license-related penalties. Hazeline chose to convert community service requirements into additional jail time because of work obligations. Before concluding the hearing, the judge warned him about the strict rules of electronic monitoring and encouraged him to stay focused on the positive direction his life was taking. The message from the court was clear: accountability matters, but so does rehabilitation. The hope is that this conviction becomes the turning point that keeps him from ever returning to court again.